Welcome to Rugby Borough Council's Planning Committee meeting. This Wednesday, the 10th of September, I'm Councillor Neil Sanderson, Chair of the committee. The meeting is being web streamed to the public through the Council's YouTube channel. During the meeting, when asked to speak, please use the push button to talk on the microphones in front of you. This will allow the camera to pan in your direction and everyone to hear you. Before we begin the formal agenda, I am obliged to read the following fire notice. There is no fire drill scheduled in the building this evening. If the fire alarm sounds, then please could I ask you, if you're physically able to make your way down to the main staircase and out of the door and congregate at the entrance to Caldecott Park. An officer of the council will give instructions on when it is safe to return to the building. Moving to the agenda, to approve the minutes of the meeting held on the 13th of August. Are members content that that is a true and accurate record? Thank you. Good on, sorry. Now, do we have any apologies for absence?
Thank you, Chair. We have apologies from Councillors Freeman, Lawrence and Srivastava, with Councillors Mystery, Garcia and Claire Edwards substituting.
Thank you for the substitutes making it tonight. Declarations of interest. To receive declarations of interest as defined by the Councillors' Code of Conduct. A. Non-pecuniary interest. B. Pecuniary interest. C. Notice under Section 107 of the Local Government Finance Act, non-payment of community charge or council tax. Thank you. Before we move to applications for consideration, we do have some public speakers tonight, and the rules for public speaking are as follows. Speakers will have 3 minutes to make their presentation. They will be warned by a short alarm when they have 30 seconds left, and then a further alarm will sound when their time has expired. Their presentation should then be brought to a halt. No extra time will be allowed. As Chair of the Planning Committee, I have granted discretion that 2 objectors may speak as the ward councillor is not available, and to allow communities' issues to be heard. In the interest of fairness, the supporter will be given up to 6 minutes to match the objector's time slot. All speakers should direct their presentations to amplify the planning matters they have previously put to us for the benefit of the committee. Speakers should restrict their comments to material planning considerations only. Any non-planning issues will be disregarded. Speakers should not introduce any additional information that was not previously been brought to the planning authority's attention, i.e. introduce late items that have not been suitably considered by officers and properly addressed in the officer's report. For councillors, deliberation not visual aid, with no visual aids or handouts may be used, and no questions to officers or councillors will be allowed. No members of the public are allowed to take part in the debate once the presentation has been given. Right. Now we'll move to item 4. Application R240975, 16 Top Park.
Thank you, Chair. Good evening. This is application R240975, located at plot 16, Top Park, Top Road, Barnacle. This application is retrospective and it is for the retention of one pitch for gypsy and traveller use, including retention of one utility building, one shed, gravel hard standing, small area block paving, small grass area, vehicular access off the access track and pedestrian access off Top Park Access Road, together with the retention of gates across both accesses and boundary fencing and the siting of 2 mobile homes. So this application has been reported to Planning Committee for determination under paragraph 5.23b of the Council's scheme of delegation. This is owing to the fact that the Chief Officer for Growth and Investment considered that the application should be determined by the local authority on such basis. So turning to the site location and the characteristics of the plot, access to plot 16 is via the access road on the western side of the Top Park site and to the west of the plot. The plot is currently enclosed on the sides by timber fencing reaching approximately 1.5 metres in height. There is a timber amenity building used as a kitchen and lounge area. To the east of this is a timber gazebo structure. A small shed lies to the rear of the amenity building near the western boundary fence. The majority of the plot is surfaced with loose stone chippings. 2 mobile homes are to be contained within the site. So this slide shows an aerial view of the wider Top Park site with plot 16 highlighted with a red outline. Turning to the photos, so the top left photo shows the western access from the Top Road Highway, and the remaining photos show an internal view of the internal access road viewing northwards towards Top Road and then within the site as well on the right. So in terms of the proposal plans, the top left shows the arrangement within the site. This includes the 2 mobile homes, one on the north and one on the south boundary, along with the outbuildings as well, which is on the western side. The remainder of the photos on this slide illustrate the nature of the mobile homes and the outbuildings. So regarding consultation responses, all technical consultees provided a stance of no objection. The Parish Council, however, offered an objection along with several neighbouring objections from local residents. The nature of these objections are summarised below and explored in more detail within the officer report. These are that it's inappropriate development in the Greenbelt, detrimental to the appearance of the area. The application fails to demonstrate or provide any evidence of any very special circumstances which could justify any development on a site in the Greenbelt. The development is not sustainable. The development will clearly be visible from public rights of way. The impact of light pollution that the development will have on the area is significant. There is inadequate drainage on site. There is a significant number of other gypsy and traveller sites in the immediate area and across the wider parish, which has resulted in a significant over-concentration of sites. The works on the site were undertaken with the full knowledge that there was a High Court injunction on this land, which was intended to prevent any such development. So turning to the principle for development, Local Plan Policy GP1 sets out the presumption in favour of sustainable development. The local plan is now more than 5 years old. Paragraph 11D, the tilted balance of the MPPF, is therefore relevant. Local Plan Policy GP2, the site is outside of the settlement boundary and upon designated Greenbelt land. Paragraph 153 of the MPPF states that when considering any planning application, local planning authorities should ensure that substantial weight is given to any harm to the Greenbelt, including harm to its openness. The proposal does not comply with any of the exception criteria for Greenbelt development as contained in paragraph 154 of the MPPF, and therefore paragraph 155 is relevant. Turning to paragraph 155, this states that development of homes and other development in the Greenbelt should not be regarded as inappropriate where the listed criteria applies. As explored in detail in the committee report for members, the scheme is not compliant with all the criteria of paragraph 155 and therefore still constitutes inappropriate development in the Greenbelt. As per paragraph 153, inappropriate development is by definition harmful to the Greenbelt and should not be approved except in very special circumstances. Very special circumstances will not exist unless a potential harm to the Greenbelt by reason of inappropriateness and any other harm resulting from the proposal is clearly outweighed by other considerations. So turning to the level of harm caused by this proposal on the Greenbelt. Local Plan Policy GP2's approach to Greenbelt development aligns itself with government guidance. The application site and plot is located within an open landscape situated to the north of Coventry. This area of the Warwickshire Greenbelt plays an important purpose in preventing Coventry merging with the settlements to the north. Until June 2028, however, Plot 16 would not be viewed in isolation, but would rather be set against the remainder of the Top Park site, as the eastern linear formation of pitches are consented until June 2028. Therefore, the views of this plot alone on its own accord from the east are limited, as they are screened by the eastern side of Top Park during this period. Likewise, views from the west of the plot will be set against the wider Top Park site. However, extending the Top Park site above that which is already consented would cumulatively erode the openness of the greenbelt and would unacceptably detract from the rural character and appearance of the area. Therefore, the proposal would constitute an encroachment into the countryside, diminishing the sense of separation between Coventry to the south and the other settlements to the north. On this basis, the development, if permitted on a permanent basis, is considered to unacceptably detract from the character and appearance of the area, in conflict with policies GP2, NE3 and aspects of policy DS2 of the local plan. Turning to the local need within the borough, the lack of gypsy and travel accommodation provision across the borough is a key consideration in the determination of this application. The council cannot demonstrate its locally set target for gypsy and traveller provision across the borough. The Rugby GTAA 2025 provides the latest available evidence to identify the accommodation needs of gypsies and travellers across the borough. This latest assessment concluded that there is a minimum requirement of 94 additional gypsy and traveller pitches across the borough over a period spanning from 2024 to 2042. Of this need, 35 are required in the first 5 years until 2029. Recent appeal decisions have subsequently reduced the council's shortfall of pitch provision during this period to 29. In conclusion, the GTAA 2025 demonstrates the shortfall of gypsy and traveller provision across the borough. The council is working towards the adoption of a new local plan which seeks to address this need. However, this emerging document is at an early stage and the relevant policies only carry limited weight in decision making. Therefore, significant weight is attributed to the contribution this proposal would make to addressing a recognised need for more gypsy and traveller sites at a local level at this current time. So turning to the personal circumstances of the occupants of the plot, evidence of the personal circumstances have been received and considered by the LPA. There are 3 children on the site, all of which are below the age of 10. A 4th child was due at the time of the application submission. 2 of the children are in education within the local area, with one of them having had recent medical needs. In support of this, the LPA have been provided with letters from educational establishments attended by the children. The applicant and his family identify as Romany gypsies, and in line with the above, the applicant has provided sufficient evidence to establish that they will qualify as having gypsy and traveller status for the purposes of assessing planning applications. Turning to the matters relating to intentional unauthorised development, a written ministerial statement dated 2015 establishes that intentional unauthorised development is a material consideration to be weighed in the determination of planning applications. An area with a lawful agricultural use in the Greenbelt has seen operational development and a change of use take place. The previous appeal decision for this plot, following the refusal of a scheme in 2023, concluded that the proposal on this site is intentional unauthorised development. Government's planning policy statement states that intentional unauthorised development is a material consideration and should be applied to all applications received after 2015. Turning to the visual impacts caused by the proposal scheme, further intensification of the site will be controlled through conditions 8 and 9 in the draft decision notice, preventing the introduction of any more structures or mobile homes than those which are presently on the plot. Condition 11 will prevent the installation of excessive or inappropriate external light sources. Whilst it is accepted that the proposal will provide an identified harm on the landscape owing to the cumulative development within the top box site, the appropriate conditions applied on this aspect, and owing to the temporary permission which is proposed, the harm is controlled. The use of the appropriate conditions in order to overcome objections or conflicts also conforms with the intentions of paragraph 28 of the Planning Policy for Traveller Sites 2024, when the Council cannot demonstrate its locally set target over a 5-year period. In terms of residential amenity, objections have been received over the cumulative impact of the level of gypsy and traveller accommodation in the locality on local services and facilities. The proposal site itself has sufficient privacy and space to meet adequate living arrangements of the applicants without compromising the amenities of those living on adjacent plots on Top Park. The nearest settled residential properties to Top Park site are around 250 metres away. Environmental Health have stated that a noise assessment was not required for the proposal. Conditions 3, 4, 5, 8, 9 and 11 in the draft decision notice will help to restrict immediate implications within the area. Turning to matters relating to highway safety, county highways were consulted and raised no objections subject to condition 7 in the draft decision notice in terms of the impact on the road network resulting from the proposal. The previous appeal decision, as mentioned earlier for this plot, stated that whilst plot 16 was to be served by the Western Access Road, it was not included within the red line boundary of this form application submission. Therefore, there was not an appropriate access from the plot all the way to the public highway, and in doing so would mean using land where the required consultation hadn't been carried out prior to the determination process. In this current application submission under consideration tonight, the site location plan provided shows the Western Access Road as part of the red line boundary for plot 16. This extends all the way from the plot to the Top Road Highway. This has therefore alleviated the issue relating to access as noted in the previous appeal decision. Therefore, the scheme complies with local plan policies D1, D2 of the local plan, and the scheme is also in compliance with paragraph 115 of the NPPF. In terms of biodiversity, local plan policy NE1 states that development will be expected to deliver a net gain for biodiversity in accordance with the mitigation hierarchy. This is echoed in paragraph 187D of the NPPF. The intentional unauthorised development which has been carried out has resulted in a net loss for biodiversity, which is contrary to the aforementioned policies. County Ecology were consulted on this application, however, provided a stance of no objection. So turning to the planning balance and conclusion, local plan policy GP2, when concerning Greenbelt development, states that proposals will only be permitted if they are compliant with national policy. The NPPF states that substantial weight should be given to any harm to the Greenbelt. Inappropriate development should not be approved except in very special circumstances, which is also echoed in Policy E of the Planning Policy for Traveller Sites. Very special circumstances will not exist unless the development's harm to the Greenbelt is clearly outweighed by other considerations. Section 9 of the committee report identified the harm to the Greenbelt arising from the application proposal. The harm to the Greenbelt is substantial, and a net loss for biodiversity has occurred, which is contrary to local plan policies and the NPPF. However, the Council does not have a 5-year supply of deliverable sites at this time, which carries weight in favour of the application. The new local plan should resolve this current issue. Until then, however, the means of addressing the identified shortfall will be through windfall proposals such as this. The intentional unauthorised development is a factor which weighs against the scheme. However, the proposal provides the applicant and their family with a home within their cultural and familial links, which carries substantial weight in favour of the application. As mentioned earlier, children are present on site who attend school and medical services in the local area. This carries substantial weight in favour of the application as a settled base will benefit them. However, it is considered the personal circumstances taken with the identified unmet need at a local level are not sufficient to justify the occupancy of plot 16 on a permanent basis when weighed against the harm identified to the Greenbelt and the other conflicts identified. As such, very special circumstances are not demonstrated as to outweigh the harm on the Greenbelt for a permanent period. However, turning to a temporary permission to authorise the use of plot 16 until June 2028, it will still be inappropriate development in the Greenbelt during this period, and this should continue to be afforded substantial weight. However, as the recommendation is one for a temporary period, the cumulative considerations of personal circumstances and the Council's unmet need would outweigh the total harm identified on a temporary basis until June 2028. This is due to the fact that the plot will be set against the wider Top Park site for the same time period. Therefore, very special circumstances necessary to justify the development for the time period recommended have been demonstrated. This is noted in the previous appeal decision for the plot and as explored in detail within the committee report. The previous matter relating to a suitable access being included within the applicant's red line boundary extending all the way to the Top Road Highway has now been alleviated, and the former appeal for the plot was dismissed on a technicality for this matter previously. A suitable and safe access to Top Road is therefore apparent for the time period until June 2028. There has been no other considerations which have arisen since the previous appeal decision for the plot which would alter the temporary permission which is recommended. Therefore, the officer recommendation is approval on a temporary permission until June 2028, subject to the conditions and informatives set out in the draft decision notice appended to the report, and the Chief Officer for Growth and Investment being given delegated authority to make minor amendments to the conditions and informatives as outlined in the draft decision notice. Thank you.
Thank you, Sam. From that, I'll go to our speakers. Can I ask? Right, yeah. Right, first of all, get the script right. If members of the committee have any technical points or questions that they want to raise with the officer. Councillor Gillies.
The first one, whether you give us a bit of background to the court injunction on the land. What information can you give us on that? That the land should not be developed, and yet there was a court injunction. What was the council involvement in?
Yeah, through you, Chair. Yes, I understand there was is a court injunction on the land. However, that doesn't stop someone putting in a planning application while there is a court injunction on the land, or for it to be determined by committee. It is a separate legal process. I believe committee were previously advised that. Appreciate it's not this committee. By, I think last time this application was considered at the time. So, yeah, it is separate to the planning process.
Yeah, sorry, I'm not quite clear on what has just been said. Was the application put, or was the building work done, or the vans moved in while that injunction was there then?
Yes, that's correct.
And so then there was an injunction to what? Get them removed?
No, the injunction on it was already in place on the land, to, which was against obviously caravans and paraphernalia being on the site. I don't have the exact wording in front of me, but as I said, that doesn't prevent a planning application coming in and for us assessing it. Obviously, this decision will then, you know, if members were minded to approve this decision.
It on then, doesn't it, really?
Well, obviously that injunction was there. Obviously, it's quite some time. The age of that injunction is quite old. But obviously it is obviously on the land, but it doesn't prevent a planning application coming in and being assessed, or if it went to appeal, the inspectorate assessing it as well, like last time.
Right, okay, thank you.
Councillor Gillies.
Sorry, yes, this sort of explanation we're getting is a bit confusing. So we've got a field with no development on it whatsoever, a court injunction takes place, and then after the court injunction, the land has intentional unauthorised development on it. So where was the planning authority fitting in this? Shouldn't they have been upholding that court injunction to retain the land as unauthorised?
I mean, obviously, the council obviously would look at the injunction. It would obviously be down, and obviously for the courts to take for them to consider that injunction. I believe the activity onto the site that occurred at the beginning of the pandemic, and obviously there was other restrictions in place at the time because of that. It wasn't progressed through the courts because then a planning application came in, obviously following the activity that went on site. That application obviously had to be considered by the authority, which it was. Members may recall, the applications were refused. The applications were then dismissed. The injunction process is entirely separate to the planning process. It's different legislation that considers it. So, yeah, you're right, there is the injunction, but from my understanding, obviously I'm not a planning lawyer, so I can't confirm with regard to the actual process, with regard to what that would follow. But the planning process is separate, but I know that obviously we haven't taken action against that injunction as a council, as far as I'm aware.
Councillor Ian Picker.
Thank you, Chair, and this is perhaps one for our interim monitoring officer. In terms of the weight that we should be affording the presence or otherwise of an injunction when determining this application, is there any guidance that you could perhaps share with committee, or is it sufficiently covered by the report and the inspectorate's conclusion that this is intentional unauthorised development?
I think we need to take into account the inspector's previous decision, and members here can listen to the objectors as well as the agent acting on behalf of the applicant. Members will see the recommendation from officers, but members are in a position to make up their own minds. However, officers will advise that I'm sure that the application, if against officers' recommendations, could win an appeal with the inspector.
Yeah, members may note from the actual officer report a copy of the appeal decision by the inspectorate is included. The inspector has also included under the section of intentional unauthorised development that the presence of the injunction, though, does not prevent applications being submitted for consideration. The inspector then didn't actually give any weight either or one way or the other when they actually then reached their conclusion, but obviously then considered the planning merits.
Thank you, Chair. In the application, it's mentioned there is a family there, and they have 3 children, and the 4th one was there, and one of those children is going to the school, and another children needs medical attention. So, in case if we are rejecting it today, where will the family go?
Through you, Chair. There's been no evidence submitted to the LPA as to where they could move to. As demonstrated in the officer report and the presentation, the council has a significant shortfall of provision across the borough, so there's not anywhere oven ready for them to be able to move to as such, which is obviously in some cases why the unmet need can lead to intentional unauthorised development, because there isn't the plots there for them to be able to move on to.
Right, now if I can move to the registered objectors, representatives for the objectors, the applicants, and then the ward council will be invited to speak. But as there's no ward councillor here today, we will go around one. The planning officer can address any material issues that from the speaker's comments, but that will again come through the chair. It won't be a random selection. Any, first of all, councillors. The committee will then go into debate after both the objectors and supporters have had their say.
I've been asked to speak on behalf of BRAID, Barnacle Residents Association Against Inappropriate Development, who want to make their position clear. They are not anti-gypsy and traveller, rather against inappropriate development, particularly as it relates to the Green Belt. Like the members of this chamber, BRAID has people from across all political spectrums and is a fair representation of the settled community in the hamlet of Barnacle. You may not know, but Barnacle is mentioned in the Domesday Book as one of the oldest hamlets in England. It therefore has historic relevance. It would be outstanding if you were not aware that the plots under consideration tonight are situated on land where RBC successfully applied for a High Court injunction to preserve the land. As I was at the hearing, I don't think any of the respondents to the application are here tonight, or indeed are still living and residing in Barnacle, the relevance of which would become clearer. The applications for the plots under consideration have previously been before this chamber and before the inspector, and I understand the High Court. Each time it is argued that the applicants need to be close to family members who reside on the adjacent land under the category of familiar and cultural links. It forms part of their special circumstances submissions. But did you know that shortly after the inspector's decision, most of those who have been living on the adjacent land migrated to pastures new? Clear evidence that the nexus to family is not something that should be given any weight. You may or may not be aware that the land adjacent to the plots under consideration is now littered with old caravans and are being advertised and rented out for £70 a month and not to gypsy and travellers. But in addition, we ask you to consider this when making your decision about tonight's application. If the seating in this chamber were rearranged or the exits to the chamber moved or widened, would it change the overall integrity of the chambers? No, it would not. So why don't you apply that logic to the application before you do not change the integrity of the land in question? Braid therefore urges you to reject this application. I cannot disagree that the application has been written using more persuasive language than previous applications, and I must applaud the author of the document. A lawyer's most valuable attribute is the skill to speak or write in a persuasive manner, but do not let word wizardry cloud the real issue. The applications are nothing more and nothing less than a breach of inappropriate development. The applications have not and continue not to show any special circumstances to justify the destruction of the green belt. In fact, Barnacle is a hamlet. It simply does not have the infrastructure and amenities to support the gypsy and traveller community. In the years and applications, refusals, appeals, dismissals and appeals is nothing more than planning ping-pong and causes disharmony. Braid invites you to conclude that there is no merit to this application, to these applications and submissions as in the past and as found by the inspector.
Could I just clarify with the point that you raised on archaeological evidence? Was any feedback from the county?
No, through you, Chair. No, there's been no evidence. There's been no feedback from the county. That's not a matter that's been considered.
Could I just ask why that wouldn't be considered? Because it is a very small hamlet and it does have historical importance. So I just wonder why that wouldn't have been considered.
County Ecology didn't raise any concerns. They didn't provide a response to the scheme, so that can only be assessed on what's in front of us. There was no concerns raised by the consultee.
Was there not another objector, sir?
I'll let the... Yes. Mr. Warwick, would you like to address the committee?
Thank you, Chair. Members, my comments apply to all of the applications before you tonight. And again, my area finds itself subject to inappropriate development in the Greenbelt with little regard to policy. To be clear, this location is in Greenbelt. It fails in every way in terms of sustainability, and the report concedes is heavily car reliant. It was also occupied in spite of a High Court injunction to prevent the land being inappropriately used. However officers try to present this report, this has been through process. It has gone to the inspector with an instruction to return this site to Greenbelt status. Instead of enforcing this, time is allowed to pass, and a fresh application is entertained with convoluted reasons presented. Had this authority abided by the inspector's decision, this should now be a reinstated site. It should be noted that this authority has had Zoopla adverts sent to it showing these caravans for rent on the adjacent land. I don't know where this has got to. The last I saw, there was ill health of officers that had prevented it being looked into. To use the term temporary to justify is ridiculous. Sadly, Barnacle knows temporary means permanent, as nothing temporary has been removed in Barnacle in the last 20 years. Now, I don't blame the gypsy and traveller community for these applications. They want and need to live somewhere. And again, the local plan that's emerging seems to make little provision in my view. But the constant perceived manipulation of policy to try to make these applications fit so that this authority can address the need is causing constant tensions between the settled and travelling communities in my area. Can this authority please start to take the Greenbelt seriously? And can we work with the settled and travelling communities to find suitable sites that work for both? Otherwise, this farcical situation will simply continue in perpetuity.
Thank you for your comments. Can I call on Mrs. Emily Temple on behalf of the applicant?
Thank you very much, Chairman, and good evening, councillors. Section 38(6) of the Planning and Compulsory Purchase Act states that development must be considered in accordance with the development plan unless there are material considerations that indicate otherwise. Plot 16 is located in the Greenbelt, where development can be allowed under paragraph 153 of the NPPF, where special circumstances can justify approval. Very special circumstances can be one single material consideration, or they can be accumulation of considerations, which I turn to now. When this application first came to committee in 2023, the long-term general need at the time was 79 pitches. That need, as per the committee report this evening, has increased to 94. The situation has got worse, not better, in terms of need. And I submit that the need weighs significantly in favour of the development. Secondly, there are no alternative sites available, and there is no supply going forward. The family would have nowhere to go, they would have a roadside existence, and this too weighs in favour of the development. The inspector's decision, as the history of the site, is a material consideration. Paragraph 53 is very clear that the only reason the inspector could not grant the permission was because of a failure at the time to demonstrate a suitable access is possible within the red line. That matter has been addressed in this application. County Highways do not object, and their condition is agreed. All other consultees have not objected. With regard to the matter of the injunction, as the planning officer pointed out earlier, paragraph 31 of the appeal decision confirms that applications can be submitted and assessed and determined. And with the matter of ecology, there are no objections, no conditions, and retrospective developments are exempt in national policy from biodiversity net gain. That's covered in the National Planning Practice Guidance and the Environment Act 2021. Moving to the fourth matter of personal circumstances, case law indicates that this is not just a material consideration, but that the best interests of children be a primary consideration. Plot 16 houses a family of 7 Romany gypsies with 3 children, all under 10, in full-time primary education at Wolvie. They are the primary carer for the applicant's mother living at Plot 1, and a sister-in-law resides with them, receives care. There are close ties to existing residents, and there are medical needs in the form of hearing and speech matters. Other considerations covered in the committee report show that character and appearance is appropriate and comparable to the existing Top Park site. The site is not away from other settlements and has good access to services and facilities required for day-to-day living. This is accepted by the inspector at paragraph 47 of the appeal report. No commercial activities are proposed, and so thus either no harm arises or mitigation is available for matters in the conditions that are suggested by the council officers, and I can confirm that those conditions are agreed. In summary then, I submit that very special circumstances do exist. This application addresses the inspector's requirements in the appeal and gives members the chance to regularise the development and have these pitches meet the unmet need. A permanent permission is requested, though I note that the committee report recommends a temporary consent. The adjacent Top Park site was afforded a 5-year temporary permission in order that sites could come forward through a local plan process and based on the personal circumstances there. If members are minded to grant a temporary permission, a full 5 years from today is requested in order to reflect the weight given to material and personal circumstances. Whilst I note that the new local plan might be expected to be adopted in 2 to 3 years' time, the matter of deliverability mentioned in the National Planning Policy Framework requires that sites be identified, allocated, adopted through the plan, applied for, consented and delivered in order to meet the supply requirements. And so that's why not just waiting for adoption of the local plan, but the actual deliverability of the sites is requested. And so a full 5 years is asked. I hope that this information is helpful and that the application can be approved this evening. My final comment is just that matters with regard to the neighbouring Top Park site that have been mentioned are not material to this application. And if there are people living on that site that shouldn't be, that's a completely separate matter to these applications, these applicants, and the material circumstances for these plots. Thank you very much.
Just that question to the officer. The reason for a temporary permission rather than a permanent?
Yeah, through you, Chair. So, as mentioned by Miss Emily Temple, the appeal decision for this plot previously, after the application was refused in 2023, is a material consideration. The appeal decision is in the appendix of the officer report, and this stated that the personal circumstances, unmet need, was not sufficient to outweigh the harm on a permanent basis. However, the appeal decision did go on to state that a temporary permission would have been suitable had it been for the highway access being included in the red line boundary. That is at paragraph 53, which says that despite these points, I'm unable to grant temporary permission for any of these schemes because of the highway access. That has now been alleviated and is included in the red line boundary extending all the way to the Top Road Highway, as mentioned in the officer report and presentation, and highways have offered no objection to the highway access that it serves as well, entering onto Top Road, sorry. And carry on. In terms of the reason as to why the temporary permission is proposed, again, this is in line with the appeal decision. It was considered that should the eastern side of Top Park, which is consented until June 2028, be removed, should these plots be consented for a longer time period, the harm on the greenbelt would be considerably more. Whereas if they're consented for the same time period until June 2028, the harm from those plots, or plot 16, would be limited because it'd be set against the wider Top Park site.
Do members have any questions for the officer on? Councillor.
Thank you. Thank you, Chair. If we take the plot number 16 out of the equation, and if there is no more plot number 16, what happens to the adjacent plots? Are they still going to be there, or are they?
Through you, Chair. Which plots are you referring to?
The one they are talking about where the advertisement was put for renting out the place.
Yeah, so that's a completely separate matter with regards to this application under consideration. The council has received allegations of that happening on parts of Top Park, and there is an enforcement investigation open on that matter, but we have no evidence to suggest that it's specifically related to plot 16. And in any event that it is, condition 6 on the draft decision notice makes the permission personal to the applicant as well. So if permission is granted, it will be personal to the applicant and his family, and that obviously would mean that it can't be rented out, and if it was, then that would be an enforcement investigation that would need to be carried out.
Councillor Gillies.
Yes, thanks, Chair. Just a question on evidence, and I'm really interested on getting complete evidence, because, you know, the applicant hasn't arrived from the planet Mars and suddenly got downloaded straight into Barnacle. They've moved from somewhere. Where have they moved from? What's the evidence of where they've lived? Do they own any properties anywhere? Have you gone into that in great depth? Because that's important. That is really important. Because, you know, in general terms, evidence has come to me that, you know, people work for a living, they earn money, and they spend their money on things. And in some cases, they buy terraced houses and rent them out. So we need to delve right into the basics of their background so they can be fully informed and we can make a decision based on evidence rather than what we're told. Thank you.
Yeah, I mean, through you, Chair, we obviously have to assess the applications on the basis of what they're submitted. We aren't provided with information about, you know, what other assets they may own. Obviously, they have put evidence together about who's living on the site, who the dependents are on the site, what medical needs they have, and they're the factors that we're looking into with regard to the very special circumstances in this application.
Sorry. So they moved into this site, plot 16. There was no permission on that site at the time they moved in. Is that correct?
Through you, Chair. Yes, that is correct. Intentional unauthorised development has occurred for the plot to be formed.
Can I just quickly, before we move into debate, just clarify exactly what we're talking about in terms of other sites on the wider Top Park area, in terms of there's been some references to rented properties. We're just dealing with these 3 applications this evening. Can we just have some definitive clarity on how that all arises?
With respect, Councillor Picker, we can only deal with applications that are in front of us.
Yeah, what we're considering, Councillor Picker, is those 3 sites tonight, plots 14, 15 and 16. We're not considering the sites next door. Does that answer your question? Okay.
I think we now move into general debate.
Well, first and foremost, Chair, I hope you'll just take a minute, because I'd just like to remember the late Bill King, who farmed the land adjacent to Top Park and was the chair of Barnacle and Shilton Parish Council for many years. He's suffered time and time again from various unsociable activities, but he's now free from that. But the key to this, that I see, is all about condition 1. And I'm sure the officer will know off the top of his head how many pitches there are that have accumulated in and around Barnacle and Shilton from the 13 sites. And he'll also know how many of those have had this condition applied and how many times has that condition been carried out. Because if the answer coming back to me is that condition has never been applied and carried out once, then of course condition 1 isn't worth the paper it's written on. And the members here are going to be making a decision about, we know that that condition cannot be enforced. Never has been.
I mean, yeah, just for everyone's clarity, condition 1 is referring to a temporary permission. Obviously, if that what tends to happen, and not just necessarily with gypsy and travel applications, but where you have a temporary permission, the applicants have the right to apply again to extend that temporary permission, and that has to be assessed then against the development plan and any material considerations at the time. Obviously, we have had it on other sites in the area where that permissions have been extended, and also extended, and sometimes they've been refused, then been on to appeal, PINs have put further temporary permissions on, and you obviously get into this sort of cyclical nature of lots of temporary permissions. And I think the difficulty with that also brings uncertainty for all involved, which of course then is why, you know, we are now trying to, through the emerging local plan, looking at actually allocating sites. So in terms of obviously at the point you're made, obviously that condition comes forward, but yes, we do then get subsequent applications to extend that period.
Could I just ask you something on the back of that? Has anybody ever been removed from Top Park then, when they've had a temporary?
I'm not aware of anyone's actually moved. I mean, also, well, obviously there's been allegations.
Has there been enforcement
to
remove somebody when they've breached a temporary?
Not through direct action, no. I'm not aware that that council has taken it on that site.
Right, thank you.
Understanding is that there is a permission on there at the moment which takes the current occupants up to 2028. But that was for a 5-year period. This recommendation from the office is for a period up to 2028.
I do understand that, Councillor Sanderson. What I'm trying to see is whether, as Councillor Gillies pointed out, whether condition 1's actually worth the paper it's written on, And actually, when we get to 2028, whether we're all going to be well, probably not us, but we're going to be sitting here again, arguing the toss about another temporary application.
Again, I mean, through you, Chair, obviously it's the applicant's right to submit an application. Obviously, if they choose not to, we as an authority, and we have done this in the past on gypsy and traveller sites, is then serve an enforcement notice. Obviously, that enforcement notice has a right of appeal. That would then go through to the inspector. And obviously what's also happened in the past is that even if those enforcement notice appeals are dismissed, the applicants then have a right to challenge that in the High Court. And obviously through the court decision it goes. Sometimes then what happens, which has happened in this case, the last application was refused by this committee, it was dismissed as appeal, it was challenged in the High Court twice. A new application now has come in to try and address the concerns of the inspector. And obviously we as officers believe that these applications now before members are addressing the concerns of the planning inspector, but we only feel it is on the basis of a temporary permission, which is what we're actually recommending.
Just to clarify on what you've said then, it's just the fact that they've moved the road into the red line.
Yeah,
that's the only change on the whole thing that's now making this acceptable.
And that's what the inspectorate also confirmed as well as outlined in the agenda. It was the access arrangements that meant that that's why the inspectorate last time didn't approve the application. So obviously these applications seek to address that concern. But obviously, these are new applications. We are obviously considering them against a new MPPF that has come out. We're obviously considering them against the very special circumstances that have been put forward. So, they are in their own right, separate applications to be considered. That inspectorate decision is a material consideration, which we have to obviously give the appropriate weight to. But, tonight these are separate decisions that we are looking at and being asked to determine.
Thank you, Chair. So I'd just like to, firstly, I'd like to thank Sam for including the full inspector's assessment within the officer's report. That's incredibly helpful, and I hope that we can continue to do that. So obviously the recommendation from officers is the temporary permission because it's viewed that will overcome the comments of the inspector's report. However, if my memory serves me, we were just asked by the Speaker for the applicants to actually consider an amendment to that to make it permanent, which is against the recommendation of the inspector in his paragraph 51, where he says that that would not meet or would not justify the grant of permanent permission. So to my mind, what we essentially have here is intentional unauthorised development within the Greenbelt that has gone through our process. It has gone to the inspector has reached a conclusion. It's then went to the High Court. The High Court dismissed that, and it's now come back before us. And I actually think that that paragraph 51, the harm to the openness of the Greenbelt, those are the fundamental matters that we should be considering here this evening. So on that basis, Chair, I am happy to move refusal on the basis of inappropriate development within the Greenbelt, contrary to the MPPF. No, on the application before us.
Okay, thank you.
There was a lot in the thank you for a very thorough presentation. It makes our lives a lot easier when we've got thorough report and thorough presentation. There was a lot in there about how the policies are, how this is contrary to a lot of the things that we have to look at. The thing that seemed to be in favour was the fact that they've got children, which was my question earlier. When they moved in, was there permission? No, there wasn't. So at that point, you're always taking quite a risk that you're going to end up with something that you do get permission for. And for us then to have to consider that, and I get all everything around that, but we're being asked to consider that on essentially a family knowing they were moving into something that didn't have permission. So in view of that, and in view of everything that was in your report that seemed to suggest it should be refused in the sense of greenbelt, biodiversity, and I get the point about the biodiversity. But all of that seems to weigh for refusal rather than approval. So I will second Councillor Picker for refusal for this.
Yeah, thanks for letting me speak again, Chair. Yes, time and time again when we've had these sort of applications come before us, we've sort of pleaded almost with the Egyptian traveller community, please put your planning application in first, go through the planning system, debate it with the local folk, and then, you know, we'll go through it that way, because there's a significant cost to fighting these things in people's time and in people's emotions, especially those people that live in those communities that are now completely overwhelmed. And of course, they're with officer time in this town hall. So the message is, apply for permission first. When you've got your permission, do your building. Because this is not so much as about blindly following policy at the complete disregard of the settled community. Because those are the people that have been living, working, feeding into the community, doing things, helping in village halls, helping on parish councils, doing things for folks. You know, that those folks are getting undermined. I live and work amongst them, and my job takes me amongst them, and some of those people are completely demoralised to a point where they just move. They've had enough. And poor old Billy's died. So, you know, I support the motion for refusal.
Just to remind members, the recommendation before you tonight is for approval for a temporary planning permission. It is not a full planning permission, and so your decision to say. So I just want to clarify that what you move for refusal is against the officer's recommendation for a temporary planning permission. Do any members have any further comments? Yes. Yes.
Working now? Oh, it's working now, thank you. Above all of this, today, this came to us, and we have a policy to say whether we could be able to build in a green belt or not. On top of it, what we have here is we have a family there, which they lived there for 5 years. And suddenly we are going to go and say it's not your home anymore. That means for me, we elected members sitting here making a judgment, and then we are just breaking up a family. And the policies are there, yes. Officers can make decision on it, but they couldn't make a decision, and it comes to the committee because we have the power to interpret the policies and procedures. So in my opinion, I think we need to have a holistic view and approve this temporary application and leave the family, and then make them aware that the approval is for until 2028, and allow them to make some arrangement. If the further applications are denied, they have to go somewhere. Without doing it, just asking them to go out, and for me, it's making a family homeless overnight. I don't support this. I support.
Can I just check,
temporary
Councillor?
thing.
You are moving the officer's recommendation for approval?
Yes, I am moving the officer's recommendation.
Thank you, Chairman. Yeah, I think I've listened to the officers, the arguments, and the balance on the for and against. Listen to the speakers from both sides of the objection and for. And I think on balance, I think we should approve the recommendation as printed by the officers. Thank you.
Can I just, can I just check, Councillor? You are moving the officer's recommendation for approval?
Yes,
two propositions before us, one for approval and one for refusal. Which one should we do? See buttons.
So, members, this evening we've had it's been moved for refusal and seconded. We've also had move for approval and seconded. As the report recommends a temporary approval, I would suggest that members vote on that initially, and we seek hands in favour, and then the chair will ask for those who oppose that.
So in terms of tonight's vote, can I see all those in favour of the officer's recommendation? Thank you. And those against? Second vote. Was that 5?
Was that 5-5? 5-4.
5-4.
Okay, we did a vote. Just clarify.
Can we just take the vote again? All those in favour of the officer's recommendation, please show.
5.
So it looks as though it falls on me. Casting vote. I think, in line with the officer's report, I will vote for the temporary permission to 2028. Move us to the next application, which is R240979.
Thank you. This is application R240979, located at plot 15, Top Park, Top Road, Barnacle. This again is a retrospective application for the retention of one gypsy and traveller pitch comprising of one static caravan, one touring caravan, one stable block used for storage, one kitchen utility building, one dog kennel, a gravelled parking area, a block paved pathway, walls and gates along the front boundary, fencing along the side and rear boundaries, and vehicular access off the internal Top Park access road. So again, this application is being reported to Planning Committee for determination under paragraph 5.23b, due to the fact that the Chief Officer for Growth and Investment considered that the application should be determined by the local authority on such basis. So, site location and characteristics. The access to plot 15, unlike plot 16, is via the main established Top Park access road, which is located to the east of the plot. The plot is enclosed on the sides by timber fencing reaching approximately 1.5 metres in height. The eastern boundary is marked by a brick wall rising from approximately 1.5 metres to 2 metres in height, within which is a vehicular access from the main Top Park access road. Within the plot is a mobile home and a single tourer caravan. To the west of the mobile home is a brick-built amenity building that serves as a kitchen and utility space. To the northwestern corner of this is a building of timber construction which is used for storage, and the majority of the plot is surfaced with a combination of loose stone chippings and block paving. So this slide shows the aerial views of the wider Top Park site with plot 15 highlighted within the red outline. Site photos, the top left shows the existing internal access road from the top road highway. The bottom left photo shows the internal access road viewing towards the top road highway. And on the right hand side, it shows the plot, the access to the plot, and then internally within the plot as well. So regarding the proposals, the top left shows the arrangement within the site. There's a mobile home on the southern boundary, and then various outbuildings which are used to serve the applicant's needs. Below this and on the right are the mobile home structure and then the amenity outbuilding as well. So again, regarding consultation responses, all technical consultees provided a stance of no objection. The parish council offered an objection along with several neighbouring objections from local residents. The nature of the objections are summarised below and explored in more detail within the officer report. Again, these are the same as the previous inappropriate development in the green belt, fails to demonstrate any evidence of very special circumstances. The development is not sustainable. It will be clearly visible from a public right of way. The impact of light pollution from the development will have a significant impact on the area. Inadequate drainage on the site, a significant number of gypsy and traveller sites in the immediate area, and a significant over-concentration within the wider parish, and the High Court injunction situation as well. So again, regarding the principle of development, policy GP1 sets out the presumption in favour of sustainable development. The local plan is now more than 5 years old. Therefore, paragraph 11D of the NPPF tilted balance is relevant. As per the previous plot, this site is also located upon designated greenbelt land. Paragraph 153 states that substantial weight is given to any harm to the greenbelt, including harm to its openness. The proposal does not comply with any of the exception criteria in paragraph 154 of the NPPF, and therefore paragraph 155 is relevant. Turning to paragraph 155, this states that the development of homes and other development in the greenbelt should not be regarded as inappropriate where the listed criteria applies. As explored in detail in the committee report for members, the scheme is not compliant with all the criteria of paragraph 155 and still constitutes inappropriate development in the greenbelt. As per paragraph 153, inappropriate development is by definition harmful to the greenbelt and should not be approved except in very special circumstances. Very special circumstances will not exist unless the potential harm to the greenbelt by reason of inappropriateness and any other harm resulting from the proposal is clearly outweighed by other considerations. So, turning to the greenbelt harm of this proposal, Policy GP2's approach to greenbelt development aligns itself with government guidance. The application site is located within an open landscape situated to the north of Coventry. This area of the greenbelt plays an important purpose in preventing Coventry merging with settlements to the north. Until June 2028, plot 15 would not be viewed in isolation, but would rather be set against the remainder of the top part site, as the eastern linear formation of pitches are consented until June 2028. Therefore, the specific views of plot 15 on its own accord from the east are limited, as it is screened by the eastern side of Top Park during this period. Likewise, from the west, the plot will be set against the wider site. However, extending the Top Park site above that already consented will cumulatively erode the openness of the greenbelt and would unacceptably detract from the rural character and appearance of the area. Therefore, the proposal will constitute an encroachment into the countryside, diminishing the sense of separation between Coventry to the south and other settlements to the north. On this basis, the development, if permitted on a permanent basis, would unacceptably detract from the character and appearance of the area in conflict with policies GP2, NE3 and aspects of policy DS2. The local need within the borough is a key consideration in the determination of this application. The council cannot demonstrate its locally set target for gypsy and traveller provision. The Rugby GTAA 2025 provides the latest available evidence to identify the accommodation needs of gypsies and travellers across the borough. This latest assessment concluded that there's a minimum requirement for 94 additional pitches across the borough between 2024 to 2042. Of this need, 35 are required in the first 5 years until 2029. Recent appeal decisions have subsequently reduced the council's shortfall of pitch provision during the first period to 29. Therefore, the GTAA 2025 demonstrates the shortfall of provision across the borough. The council is working towards the adoption of a new local plan which seeks to address this need. The emerging document is at an early stage and the relevant policies only carry limited weight in decision making. Significant weight is attributed to the contribution this proposal would make to addressing a recognised need for more gypsy and traveller sites at a local level at this current time. So turning to the personal circumstances for the occupants of this plot, evidence of the personal circumstances of the current applicants has been received and considered by the LPA. Living on plot 15 is the applicant and their partner. There are 2 children dependent on them who reside on the site. One of the children is under the age of 10. The other child's age has not been disclosed. Out of the young children on the plot, there's a child with medical needs who is receiving ongoing medical care and therapy in the local area. The applicant has familial and cultural links with other occupiers of Top Park and relatives living in close proximity to the site. The applicant and his family identify as Romany Gypsies. In line with the above, the applicant has provided sufficient evidence to establish that they will qualify as having Gypsy and traveller status for the purpose of assessing planning applications. So turning to matters related to intentional unauthorised development, a written ministerial statement in August 2015 establishes that intentional unauthorised development is a material consideration to be weighed in the determination of planning applications. An area with a lawful agricultural use in the Greenbelt has seen operational development and a change of use take place. The previous appeal decision for this plot concluded that a proposal on this site is intentional unauthorised development. Intentional unauthorised development is a material consideration and should be applied to all applications received after the 31st of August 2015. The visual impacts. Further intensification of the site will be controlled through conditions 8 and 9 in the draft decision notice, preventing the introduction of any more structures or mobile homes than those which are presently on the plot. Condition 11 will prevent the installation or excessive or inappropriate additional external light sources. Whilst it is accepted that the proposal will provide an identified harm on the landscape, owing to the cumulative development within the wider Top Park site, the appropriate conditions applied on this aspect, and owing to the temporary permission which is proposed, the harm is controlled. The use of appropriate conditions in order to overcome objections or conflicts also conforms with the intentions of paragraph 28 of the planning policy for traveller sites when a council cannot demonstrate its locally set target over a 5-year period. In terms of residential amenity, objections have been received over the cumulative impact of the level of gypsy and traveller accommodation in the locality on local services and facilities. The proposal has sufficient privacy and space to meet adequate living arrangements of the applicants without compromising the amenities of those living on adjacent plots on Top Park. The nearest settled residential properties to Top Park are around 250 metres away. Environmental Health have stated that a noise assessment is not required for the proposal. Conditions 3, 4, 5, 8, 9 and 11 in the draft decision notice will help to restrict amenity implications in the area. Turning to matters relating to highway safety, County Highways raised no objections subject to Condition 7 in terms of the impact on the road network resulting from the proposal. Again, the previous appeal decision for the plot stated that whilst plot 15 was to be served by the existing internal access road, which is also there to serve the eastern side of Top Park as well, it was not included within the red line boundary of the application submission. Therefore, there was not an appropriate access from the plot all the way to the public highway, and in doing so would mean using land where the required consultation hadn't been carried out prior to the determination process. For context, the central internal access road was granted a temporary permission until June 2028 for gypsy and traveller use, in line with the eastern side of the site. In this current application submission, the site location plan provided shows the internal service road as part of the red line boundary for plot 15 and extends all the way to the Top Road Highway, and has alleviated the previous issue from the appeal for the plot. Therefore, the scheme complies with local plan policies D1 and D2 of the local plan, and the scheme is also in compliance with paragraph 115 of the NPPF. Regarding biodiversity, local plan policy NE1 states that developments will be expected to deliver a net gain in biodiversity and be in accordance with the mitigation hierarchy. This is echoed in paragraph 187D of the NPPF. The intentional unauthorised development which has been carried out has resulted in a net loss for biodiversity, which is contrary to local plan policy NE1. Ecology were consulted on the application and provided a stance of no objection. So turning to the planning balance in conclusion, local plan policy GP2 when concerning green belt development states that proposals will only be permitted if they are compliant with national policy. The NPPF states that substantial weight should be given to any harm to the greenbelt. Inappropriate development should not be approved except in very special circumstances, which is also echoed in Policy E of the Planning Policy for Traveller Sites 2024. Very special circumstances will not exist unless the development's harm to the Greenbelt is clearly outweighed by other considerations. Section 9 of the committee report identified the harm to the Greenbelt arising from the application proposal. The harm to the Greenbelt is substantial. A net loss for biodiversity has also occurred, which is contrary to local plan policy NE1. Again, the council does not have a 5-year supply of deliverable sites at this time, which carries weight in favour of the application. The new local plan should resolve this current issue. Until then, however, the means of addressing the identified shortfall will be through windfall proposals, such as this. The intentional unauthorised development is a factor which weighs against the scheme. However, the proposal provides the applicant and their family with a home within their cultural and familial links, which carries substantial weight in favour of the application. Children are present on site, one of which has medical needs and attends nearby services. This carries substantial weight in favour of the application, as a settled base will benefit them. However, the personal circumstances taken with the identified unmet need at a local level are not sufficient to justify occupancy of plot 15 on a permanent basis when weighed against the harm identified to the Greenbelt. As such, very special circumstances are not demonstrated as to outweigh the harm to the Greenbelt for a permanent period. Turning to a temporary permission to authorise the use of plot 15 until June 2028, it would still be an appropriate development during this period, and this should continue to be afforded substantial weight. However, as the recommendation is one for a temporary period, the cumulative considerations of personal circumstances on site and the council's unmet need would outweigh the total harm identified on a temporary basis until June 2028, as the plot will be set against the wider Top Park site. Very special circumstances necessary to justify the development for the time period recommended have been demonstrated. This is noted in the previous appeal decision for the site and as explored in detail within the committee report. The previous matter relating to a suitable access being included within the applicant's red line boundary extending all the way to the Top Road Highway has now been alleviated, and the previous appeal for this plot was dismissed on a technicality for this matter. A suitable and safe access to Top Road is therefore apparent for a period until June 2028. There has been no other considerations which have arisen since the previous appeal on the plot which would alter the temporary permission which is recommended. Therefore, the officer's recommendation is that application R240979 be approved on a temporary permission until June 2028, subject to the conditions and informatives set out in the draft decision notice appended to the report, and the Chief Officer for Growth and Investment being given delegated authority to make minor amendments to the conditions and informatives as outlined in the draft decision notice. Thank you.
So I want to... No? Ms. Terry Byrne.
Thank you. I'm going to reiterate quite similar to what I said previously, but add some different content. Again, I have to remind you that Barnacle is a hamlet. It has huge historic value to this area. There is an injunction on that land. It has been the choice of the Rugby Borough Council not to enforce that injunction, but there's nothing stopping them, despite planning application being in, from enforcing that injunction. What I'd like to focus on this time is the familiar and cultural links. I'd ask you not to ignore the fact that the cultural links are those of the people on Top Park, the land adjacent. I will reiterate again that the majority of those people migrated after the injunction to pastures new. And after the inspector's decision, there was a mass migration of the Gypsy and Traveller community from that park, therefore leaving it open for a commercial activity, which I say is relevant because that takes away the cultural links that are being argued here today. There are no cultural links with the adjacent park. Please do not be fooled into believing that. Likewise, I've heard about red lines. I'm not a planning person, I'm just a resident from Barnacle. But again, I bring you to the analogy that if we move the doors in this chambers or the seats, that does not change the integrity of these chambers. All it does is make a different access. And I'd ask you to apply that again towards the application on plot 15. It is concerning that a lot has been riding on the cultural links and the children. Well, of course, Councillor Gillis was right. There are children, and where did they come from? Where's the history of their medical background? And we all feel extremely sorry, or I know my neighbours do, that these children have got special medical needs. But that doesn't take away the fact that they were somewhere before they came to Barnacle. They were being cared for somewhere before they came to Barnacle. And please don't be fooled that they will be put on the side of the road if this application were not successful. That would certainly not happen. There is a duty by the council to house them. I'd also say that if we're looking at what is in the best interest of these children, to have them moved now at this stage in their life would clearly be better for them than to wait for 3 years on a temporary permission and then look at moving them. That certainly would not be in their best interest. And if you're looking at the primary consideration of the children, I'd ask you to consider that tonight. Thank you. All right, off to go.
Councillor Adrian Warwick.
Thank you, Chair. I will press that again. Thank you very much, Chair. Yes, I will. I've listened to the debate with interest, and I've listened to comments for and against. There are sites we have said that we can't consider tonight or hear about that are up for rent, yet the overriding reason for approval is for need. If these caravans that are on Zoopla were available to be used, then they would meet the need. But that seems to be a separate issue. This authority seems to have taken no action to look into why these caravans aren't available for use, but they would meet the need. But that's a separate issue, we're told. And applying the logic that we discuss, if a family arrived tomorrow on Caldercut Park with children with nowhere to go, would you let them stay till June 2028? I don't think you would. So I think I would ask that the rural area and the Greenbelt is treated with the respect that policy requires it to be treated with. And we have to consider that there is accommodation available in this area. And residents in Barnacle have supplied that evidence to this authority and to the knowledge, and I've seen the email trail that the residents have sent, very concerned to me. Nothing's been done due to officer illness to look into why these caravans are available for rent on the adjacent plots, yet we are told that is not a consideration. Well, if you want to come and discuss need, I would say that that is very much a consideration. Thank you.
Ask Emily Temple if she can make the case now.
Thank you, Chairman. I won't seek to repeat in full my previous comments, but just to pick up on a couple of points and questions that councillors had in the previous debate. Firstly, just to remind that the highway matter has been corrected from the appeal. Second, that the injunction does not prevent an application from being considered and assessed. The requirement for a planning application is to be considered against the development plan and the material considerations put forward. Third, that the family has been accepted as meeting the definition of a Romani Gypsy. Romani Gypsies are protected by the Race Relations Act and the Public Sector Equality Duty, which requires culturally appropriate housing accommodation to be provided for them. In this situation, there is no supply of sites or alternative sites for them to go, and so that public sector equality duty needs to be given weight in the assessment of this application. With regard to the unauthorised development, the inspector also comments that the planning system is not punitive. Retrospective applications can be made and an approval of them seeks to regularise those developments. To take a different view from the officer's recommendation or the inspector requires there to be a material change in circumstances. And the only change that I can see is that the need, independently assessed and published by the council has increased from 79 to 94. And that is why additional, either a permanent consent or a full 5-year consent is requested by the applicants, because I don't consider that additional sites will come forward in time by 2028. But do note the officer's recommendation and ask that that is given weight in your considerations this evening. Thank you.
Can I just get one thing clarified by the officer? These applications are personal to the applicants. They're not a catch-all for anyone who would want to live there.
Through you, Chair, yes, that is correct. As per the previous application under consideration, I believe it's condition 6 in the draft decision notice, which makes the permission, if granted, personal to the applicant. Yes, it's condition 6 in draft decision notice.
Yeah, just to clarify another point from that's obviously been raised is in terms of the topic of need. As one of the speakers mentioned, there's been a new Gypsy and Traveller assessment done at the beginning of this year. That obviously has identified a need. That also, though, when looking at that need, does take account of other sites that are potentially unauthorised. It also takes account of sites that, well, I suppose unauthorised across the borough when it actually calculating that need. The other point I was going to make is obviously there's been some talk about familial links. With it, obviously, that is obviously only one aspect of the very special circumstances that have been put forward by the applicants. It's obviously down to this committee to determine how much weight they give that, but there are other factors as well as part of those very special circumstances that have been stated tonight. There is an ongoing enforcement investigation with regard to the allegations about caravans up for rent on a neighbouring site. We are well aware of that. There are others in the area as well, and that is an ongoing investigation with us and other authorities.
Thank you.
Just for clarification, you were saying, obviously to make us feel a bit more secure, that the sites are named and are only to be for the people that have applied for the temporary permission. Is that correct?
Yes, that's correct. The condition reads as shall only be used by the applicant, his spouse, children and family. But that has been amended to be dependents instead of family in the addendum.
Right. So on the site where the caravans are for rent, was that site down to one person and one name, or was that just left open on that occasion?
To be fair, I don't have the details in front of me exactly on that. That's part of an ongoing enforcement investigation, but if there is, that's something we can look at.
Well, it wasn't so much about looking at it, it was to know whether we were to feel a bit more secure with it or not.
I mean, obviously, yeah, the decisions, the applications that are before you tonight are, have got specific names in them. I know of recent appeal decisions in the area. The inspectorate hasn't been making them personal, has been making them just tying it to the Gypsy and Traveller community, and hasn't been making them personal. And I think the last 4 appeal decisions we've had in the borough, obviously with this recommendation, is actually making it personal to the individual and their family.
Councillor Gillies.
Thanks, Chair. Just a point of clarification, really. Has been spoken about the land with the injunction on it, and it's quite possible to put in a planning application with the land with an injunction on it. But does that refer to a retrospective application after the development's taken place? And could we give a really clear response as to why the enforcement wasn't carried out with the injunction on that land to keep that land open without development? Because there are people out there who want to know, why wasn't it enforced? Why did you allow the land to be developed? Unintentional, development. We want to know.
I mean, obviously, you mentioned before, when that unauthorised activity took place and the timing of that. Obviously, then it was followed very quickly by a planning application that came in. Obviously, it was the start of the pandemic, and then obviously the authority, the legal advice out at the time was obviously to then determine the applications. And obviously, we've been going through a process at the moment of applications coming in, applications being dismissed, going to inspectorate, going to the High Court. This is the latest of that. But however, the injunction is still on the site. So, you know, as I said, that is a separate legal process that we would take separate legal advice on.
Sorry, I've just put a new record on, sorry. We've already made a decision, haven't we, really? You know, because clearly the last decision was effectively a permanent decision, because there's no evidence that this council can put forward to us that can say anything otherwise. A temporary permission is a permanent permission. Now, but it is. There's no evidence to say any other site in the whole of the Borough of Rugby has been brought back to green fields. Now, can you imagine living in a settled community and development taking place over an Easter holiday or a Christmas holiday, and no one can be contacted, nothing happens, and the development happens? Do you realise how upsetting that is to members of the community? It is soul-destroying when some of those folks have cared tirelessly for their communities, cared for them, out on litter picks, you know, all the things they've done for their community. They see the development taking place without any permission. Now, we've opened the door for them, haven't we? We've opened the door because anyone that wants to do some development, happen to be a Gypsy traveller in our borough, they just do something retrospective, and they know when they go through the system, they're ending up with a permanent permission. It's obvious. It's there for us to see. Clearly, we've had 25 years worth of it. So I'm moving refusal.
So that's been moved for refusal by Councillor Gillies and seconded by Councillor Garcia. And that's a...
Thank you, Chair. I'm moving for approval with the same point that they have children and there is a family there, and without giving them a proper channel to go somewhere and live, I don't think it's appropriate for us to rip their home. So I move for approval.
Thank you, Mr. Chairman. I will move the recommended as set out in the report and second the motion just put by my colleagues.
We have two propositions before us, one to approve and one to refuse, so we will take them accordingly. Those in favour of approval, please show. Oh, sorry, did we get that? 5? Yeah. In line with the convention on decision making, I will be voting in favour of the officer's recommendation. Application R240980.
Thank you. This is the final application of the night. Application R240980, located at Plot 14, Top Park, Top Road, Barnacle. The scheme is for the retrospective planning application for the retention of one number Gypsy and Traveller pitch comprising of one static caravan, one touring caravan, 1 timber dog kennel, 1 stable block used for storage, a paved parking area, gravel pathway, red brick walls and metal gates to the front boundary, timber fencing to the side and rear boundaries, and vehicular and pedestrian access off the central Top Park access road. Again, this application is being reported to Planning Committee for determination under paragraph 5.23b of the Council's scheme of delegation, owing to the fact that the Chief Officer for Growth and Investment considered that the application should be determined by the local authority on such basis. So site location and characteristics. Access to plot 14 as per plot 15 is via the main established Top Park access road, which is located to the east of the plot. The plot is currently enclosed on the sides by timber fencing reaching approximately 1.5 metres in height. The eastern boundary is marked by a brick wall rising from approximately 1.5 metres to 2 metres in height, within which is a vehicular entrance from the main Top Park access road. Within the plot is a single mobile home and a Toro caravan. In the northwestern corner of the plot is a former stable building which the applicant uses for storage purposes. The site comprises of a small grass area used for amenity purposes, with the remainder of the site surfaced with gravel and block paving. This slide shows an aerial view of the wider Top Park site, with plot 14 highlighted in the red outline. This plot is the southernmost of the plots under consideration tonight. In terms of the site photos, the top left photo shows the existing access from the Top Road Highway. The bottom left again shows the internal access road viewing northwards. The top right shows an aerial view of the plot showing the mobile home on the southern boundary, the Toro located on the northern boundary, and in the top left corner is a former stable building used for storage. The bottom right shows views from within the site. So regarding the proposal plans, the top left shows the general arrangement within the site as demonstrated in the aerial photograph on the previous slide. The remainder of the photos illustrate the nature of the existing mobile home and outbuildings. Regarding consultation responses, all technical consultees provide a stance of no objection. The Parish Council offered an objection along with several neighbouring objections from local residents. The nature of these objections are summarised on the slide and explored in more detail in the officer reports. These are the fact that it's inappropriate developing the greenbelt, detrimental to the appearance of the area. The application fails to demonstrate or provide any evidence of very special circumstances which could justify any development on the site in the greenbelt. The development is not sustainable. The development will clearly be visible from a public right-of-way. The impact of light pollution that the development will have on the area is significant. Inadequate drainage on the site. There is a significant number of other gypsy and traveller sites in the immediate area and across the wider parish, which has resulted in a significant over-concentration of sites. The works on the site were undertaken whilst there was a High Court injunction on the land. So, regarding the principle of development, Local Plan Policy GP1 sets out the presumption in favour of sustainable development. The local plan is now more than 5 years old, therefore paragraph 11D, the tilted balance of the NPPF, is therefore relevant. In terms of Local Plan Policy GP2, the site, again, is outside of a settlement boundary and upon designated greenbelt lands. Paragraph 153 of the NPPF states that we're considering a planning application, local planning authorities should ensure that substantial weight is given to any harm to the greenbelt, including harm to its openness. The proposal does not comply with any of the exception criteria in paragraph 154 of the NPPF, and therefore paragraph 155 is relevant. Turning to paragraph 155, this states that development of homes and other development in the greenbelt should not be regarded as inappropriate where the listed criteria applies. As explored in detail in the committee report for members, the scheme is not compliant with all of the criteria of paragraph 155 of the NPPF and therefore constitutes inappropriate development in the greenbelt. As per paragraph 153, inappropriate development is by definition harmful to the greenbelt and should not be approved except in very special circumstances. Very special circumstances will not exist unless the potential harm to the greenbelt by reason of inappropriateness and any other harm resulting from the proposal is clearly outweighed by other considerations. Turning to the level of harm caused to the greenbelt from this scheme, Policy GP2's approach to greenbelt development aligns itself with government guidance. The application site is located within an open landscape situated to the north of Coventry. This area of the Warwickshire Greenbelt plays an important purpose in preventing Coventry merging with settlements to the north. Until June 2028, Plot 14 would not be viewed in isolation, but would rather be set against the remainder of the Top Park site, as the eastern linear formation of pitches are consented until June 2028. Therefore, views of the development on its own accord from the east are limited, as they are screened by the eastern side of Top Park site during this period. Likewise, from the west, the plot would be set against the wider Top Park site. However, extending the Top Park site above that already consented will cumulatively erode the openness of the greenbelt and would unacceptably detract from the rural character and appearance of the area. Therefore, the proposal will constitute an encroachment into the countryside, diminishing the sense of separation between Coventry to the south and other settlements to the north. On this basis, the development, if permitted on a permanent basis, would unacceptably detract from the character and appearance of the area, in conflict with policies GP2, NE3 and aspects of policy DS2 of the local plan. Regarding local need within the borough, the lack of gypsy and traveller accommodation across the borough is a key consideration in the determination of this application. The council cannot demonstrate its locally set target for gypsy and traveller provision across the borough. The Rugby GTAA 2025 provides the latest available evidence to identify accommodation needs of gypsies and travellers across the borough. The latest assessment concluded that there is a minimum requirement of 94 additional pitches across Rugby Borough from a period of 2024 to 2042. Of this need, 35 are required in the first 5 years until 2029. Recent appeal decisions have subsequently reduced the council's shortfall of pitch provision during the first period to 29. This published document demonstrates the shortfall of provision across the borough at this current time. The council is working towards the adoption of a new local plan which seeks to address this need. This emerging document, however, is at an early stage and the relevant policies only carry limited weight in decision making. Significant weight is attributed for this proposal to the contribution this proposal will make in addressing the recognised need for more private gypsy and traveller sites at a local level at this current time. Turning to the personal circumstances, evidence of the personal circumstances of the current applicants has been received and considered by the LPA. Living on plot 14 is the applicant, their partner and their 5 children, who are all dependent on them and under the age of 10. 2 of the children attend school in the local area. The applicant has cultural links to other occupiers in Top Park and relatives living in close proximity to the site. The applicant and his family identify as Romany gypsies. In line with the above, the applicant has provided sufficient evidence to establish they will qualify as having gypsy and traveller status for the purposes of assessing planning applications. Plot 14, so turning to matters on intentional authorised development, Plot 14 has been occupied as a gypsy and traveller pitch for around 15 years. The written ministerial statement in 2015 establishes that intentional unauthorised development is a material consideration to be weighed in the determination of planning applications. An area with a lawful agricultural use in the Greenbelt has seen operational development and a change of use take place. The previous appeal decision for this plot concluded that a proposal on this site is intentional unauthorised development. Planning policy statement in August 2015 states that intentional unauthorised development is a material consideration that should be applied to all applications received after August 2015. Turning to the visual impact of the proposal scheme, further intensification of the site will be controlled through conditions 8 and 9 in the draft decision notice, preventing the introduction of any more structures or mobile homes than those which are presently on the plot. Condition 11 will prevent the installation of excessive or inappropriate additional external light sources. Whilst it is accepted that the proposal will provide an identified harm on the landscape owing to the cumulative development within the wider Top Park site, the appropriate conditions applied in this aspect and owing to the temporary permission which is proposed, the harm is controlled. The use of appropriate conditions in order to overcome objections or conflicts also conforms with the intentions of paragraph 28 of the Planning Policy for Traveller Sites 2024. Objections have been received over the cumulative impact of the level of gypsy and traveller accommodation in the locality on local services and facilities. The proposal has sufficient privacy and space to meet the adequate living arrangements of the applicants without compromising the amenities of those living on adjacent plots on Top Park. The nearest settled residential properties to Top Park are around 250 metres away. Environmental Health have stated that a noise assessment is not required for the proposal. Conditions 3, 4, 5, 8, 9 and 11 will help restrict amenity implications in the area as outlined in the draft decision notice. Turning to matters relating to highway safety, County Highways raised no objections subject to Condition 7 in terms of the impact on the road network resulting from the proposal. The previous appeal decision for the plot stated that whilst Plot 14 was to be served by the internal access road, it was not included within the red line boundary of the application submission. Therefore, there was not an appropriate access from the plot all the way to the public highway, and in doing so would mean using land where the required consultation hadn't been carried out prior to the determination process. For context, the central internal access road, which serves Plot 14 and 15 previously under consideration, was granted temporary permission until June 2028 for gypsy and traveller use as per the permission on the eastern side of the site. In the current application submission for plot 14 before you tonight, the site location plan provided shows the internal service road as part of the red line boundary for plot 14 and extends all the way from the plot to the top road highway, and has therefore alleviated the issue relating to access as noted in the appeal decision for the plot previously. Therefore, the scheme complies with local plan policies D1 and D2 of the local plan and is also in compliance with paragraph 115 of the NPPF. Turning to biodiversity, policy NE1 of the local plan states that development will be expected to deliver a net gain in biodiversity and be in accordance with the mitigation hierarchy. This is echoed in paragraph 187D of the NPPF. The intentional unauthorised development which has been carried out has resulted in a net loss for biodiversity which is contrary to local plan policy NE1. County Ecology were consulted on the application and provided a stance of no objection. Turning to the planning balance and conclusion, local plan policy GP2 when concerning greenbelt development states that proposals will only be permitted if they are compliant with national policy. The NPPF states that substantial weight should be given to any harm to the greenbelt. Inappropriate development should not be approved except in very special circumstances, which is also echoed in Policy E of the Planning Policy for Traveller Sites 2024. Very special circumstances will not exist unless the development's harm to the greenbelt is clearly outweighed by other considerations. Section 9 of the officer report identified the harm to the greenbelt arising from the application proposal. The harm to the greenbelt is substantial. A net loss for biodiversity has occurred, which is contrary to local plan policy NE1. However, again, the Council does not have a 5-year supply of deliverable sites at this time, which carries weight in favour of the application. The new local plan should resolve this current issue. Until then, however, the means of addressing the identified shortfall will be through windfall proposals. The intentional unauthorised development is a factor which weighs against the scheme. However, the proposal provides the applicant and their family with a home within their cultural and familial links, which carries substantial weight in favour of the application. There are children present on site who are all under the age of 10 at the time of the application submission. This carries substantial weight in favour of the application as a settled base will benefit them all. As mentioned previously, 2 children attend school in the local area. However, the personal circumstances taken with the identified unmet need at a local level are not sufficient to justify occupancy of plot 14 on a permanent basis when weighed against the harm identified to the greenbelt and other conflicts which have been identified in the officer report. As such, very special circumstances are not demonstrated as to outweigh the harm on a greenbelt for a permanent period. Turning to a temporary permission to authorise the use of plot 14 until June 2028. It would still be inappropriate development during this period and this should continue to be afforded substantial weight. However, as the recommendation is one for a temporary period, the cumulative considerations of personal circumstances and the Council's unmet need would outweigh the total harm identified on a temporary basis until June 2028, as the plot will be set against the wider Top Park site. Very special circumstances necessary to justify development for the time period recommended have been demonstrated. This is noted in the previous appeal decision for the site and is explored in detail within the committee report. The previous matter relating to a suitable access being included within the applicant's red line boundary extending all the way to the top road highway has now been alleviated, and the previous appeal was dismissed on a technicality for this matter. A suitable and safe access to top road is therefore apparent for a period until June 2028. There have been no other considerations which have arisen since the previous appeal for the plot which would alter the temporary permission which is recommended tonight. Therefore, the officer recommendation is that the application be approved on a temporary permission until June 2028, subject to the conditions and informatives set out in the draft decision notice appended to the report, and the Chief Officer for Growth and Investment being given delegated authority to make minor amendments to the conditions and informatives as outlined in the draft decision notice. Thank you.
Do members have any questions for the officers? Nope. Oh, Councillor Simpson-Vince.
You talked in just now about providing a settled environment for the children as a special circumstance, but it doesn't justify permanent, and so it's only temporary. So I'm just curious on how we're defining settled, because if you follow it through, if this goes through in June 2028, they haven't got permission again, and we're saying we're not looking at permanent. So just curious on definition of settled.
Through you, Chair. Yeah, the intention is that the 3 years will give sufficient time for the family to seek alternative provision in terms of local schools if required, if they have to move a significant distance away. So 3 years essentially is the buffer that would allow them to make the necessary arrangements should they have to move in the future.
Yeah, just a question on condition 6, really. I know we've got a named person in there in the family. How is that going to be policed, and how often will it be policed?
Yeah, I mean, through you, Chair, you may be aware there is the gypsy count that occurs every 6 months. That's been a requirement by the government for quite a number of years now. That occurs in January and July. Whilst obviously that looks solely at the number of caravans on site, if it has been brought to the council's attention that it is looking like there are occupants on site who shouldn't be on site, then obviously we would then instruct our enforcement team to investigate that further, and in this particular case, whether that condition has been breached or not.
Councillor Garcia.
Yeah, just going back to Councillor Simpson-Vince's point, if the special circumstances to allow 3 years for people to look at schools or whatever, does that mean it can't come back as a special circumstance in 28?
I mean, through you, Chair, it will depend on what special circumstances are cited by the applicant at the time. It may be that... Well, it could be more children, of course, in 3 years' time on the site. Then that's a possibility. It may be that some children have moved on, but we would obviously assess the application at the time based on the very special circumstances that come forward.
Those children that are already mentioned, that you already have in all the reports, given that they've had the 3 years, does that mean that that can't come back as a special circumstance for those children?
No, it can still come back for those children.
Okay, thank you.
Can we move into general debate? My apologies. Can I ask whether Terry Byrne wants to make any comment on this one?
Thank you. Again, I think I have to reiterate that about the cultural links and family links. I heard it should carry weight. That is the submission's been made. I can't help but say once again, there's no weight to carry to it. There is no cultural and family links in the adjacent plot or nearby. That's just, again, a red herring. It is just words that have actually no meaning or evidence. As Councillor Gillis says, this whole application lacks evidence. I have to support what Councillor Warwick says about alternative sites. There is one next door. So, again, please place no weight on the fact that we are being told there are no alternative sites, because there are. I have noticed while listening to this evening and looking at this application and the Shilton and Parish Council's objections, and I note there's an objection about the inadequate drainage on the site. I then hear my friend over there say about the controlled harm, and if you look at condition 10, that talks about the drainage and wastewater, and even though they've been on this site for the amount of years they have, that still hasn't been resolved, and that must be a concern for you, especially if we have all these children on a site where there's still the drainage and wastage problem that's never been resolved, unless I can say anything further.
I'll just get the officer to answer that specific point. Would you turn your mobiles off, please?
Sorry, through you, Chair. So the intention of condition 10 is that should this application be approved, that within 3 months of the date of the decision notice, the applicant has to provide the LPA with details of adequate drainage and wastewater disposal. So the LPA will then receive this and assess it to ensure that it's suitable for the site, and then when it's approved in writing, the details have to be carried out and implemented in full within a 3-month period. So the conditions there to ensure that the disposal and drainage and wastewater is apparent on the site.
Thank you.
Absolutely. Okay, so we're looking, I mean, councillors have raised excellently the points about temporary and permanent. Top Park came into existence in 2002 on a temporary application. We're now talking in 2025 about the drainage systems on the site, which still, I believe, are just simply into the ditches there. So we are 23 years down the line on temporary applications that just get renewed and renewed and renewed. And your officer has conceded that you'll consider the special circumstances in 2028 and will extend the temporary consent again, because the special circumstances will remain the same. March 2025, caravans were available for rent in this area. It was brought to your attention, and we're told in September 2025 there are still ongoing investigations. No action's been taken. That's 6 months in my reckoning. It was raised with local councillors. Myself and Councillor Moundis took an interest in action. It was raised with our local MP. I don't know if he's had any action. So all I'm saying is temporary means permanent. And some of these things that we're told are going to be dealt with within 3 months, when we've seen this going on for 23 years, excuse us if we find that amusing, because it just isn't going to.
Thank you very much, Chairman. I won't seek to repeat previous comments, but I think just to reiterate the personal circumstances, that the site has been occupied since 2010, and there are 5 children, all under the age of 10, and they have family links to the wider site. Some of the children are registered at Wolvie Primary, and others obviously would benefit, the younger ones, from access to future education. A question was raised about what settled means, and under paragraph 13 of the planning policy for traveller sites, it effectively refers to any site is better than no site in terms of providing a settled base, a consistent and secure and safe base for the family and particularly for the children, and that's so that they can have access to educational and medical services and facilities. So I hope that provides a bit of clarification on that point. That's all, sir. Thank you.
Can we now move into general debate? Are you making a...
There is, of course, only primary education available at Wolvie, isn't there? So does that mean that when the children get over that age group, that special need no longer exists?
I mean, through you, Chair, it will also be based on the circumstances put forward and whether those children are in mainstream education or not, and whether that's the evidence that they put forward at the time.
I mean, I suspect what is about to happen is we're about to have the same debate we've had twice before and come to the same conclusion. So I will rattle through it again. What we have before us is intentional and authorised development within the Greenbelt, contrary to paragraphs 153, 154 and 155 of the National Planning Policy Framework, and unsustainable development contrary to our own extant local plan. So for those reasons, I would move refusal.
Go on, I'll second that, but come on, we've got to draw it to attention to folks that might be listening and to the council and other councillors. You know, just imagine what would happen. Every planning application that came to this council was retrospective. Can you imagine utter chaos we'd be in? You know, we've got to take that into account. And the other thing is that the really serious point here is the impact on our settled communities. Communities with a living with it year after year after year, and the site's expanding and expanding and expanding. Can you imagine what their minds and their well-being is like now, thinking that they're absolutely at a loss, hopeless? We've got to start looking after our communities as well as Egyptian Traveller Site, but do it in a proper planned way, not through intentional authorised development. So I'll second the refusal.
Just on that point, Councillor, I'm sure with your experience, you will well remember quite a number of applications on different matters coming to this planning committee which were retrospective. Quite a number of them. They weren't all for travellers, they were for lots and lots of reasons that retrospective applications were submitted.
That's correct, Chair, but remember the Egyptian Traveller ones, they're all retrospective, 100%.
Could I just, sorry, butt in?
No.
No?
Yes, you can.
Thank you.
I was looking for lights.
Is it on anyway?
I thought he said no, I know, I thought, blimey. O'Reilly. Can I just say, and it's no reflection on our planning officers, because I think both of them have been put in a difficult position tonight. Sam's done a wonderful report, and Richard, you've answered all the questions really very thoroughly, as have you, Sam. So I'm not saying this on any reflection, really on any of you, but I do feel really let down by the system. I think when there's been injunctions on sites and we've gone through everything and we've tried to do it all properly, I don't particularly mind it's been retrospective planning permissions, because that is absolutely available to them. I just wonder why we have never dealt with this in the first instance, dealt with it properly as we would if that was somebody building a house somewhere and hadn't got planning permission. And I do feel when I've read that report, very thorough report as it was, a bit let down tonight.
I mean, yeah, duly noted, Councillor Garcia, and obviously, again, note your comments. Obviously, we work within the processes and legislation that we have, and there are at times when that is very frustrating for officers as well. Yeah, I mean, hindsight's a wonderful thing. We can all learn from certain things, and I do feel that we are perhaps in a stronger position now than we have been before when looking at sites. We obviously now, particularly with these types of applications, we are trying to make progress now with our local plan, and actually trying to now address this matter, which has, you rightly say, has come before committee many times.
Thank you, Chair. There is a little bit of a, I know Councillor Garcia is thinking that she's let down by the system, but what about the gypsy and travellers families? They need to have 90 houses in this borough, but we haven't built them any, and don't we think we are letting a whole community down in the name of a system? Saying that, again, under the humanity, I'm thinking we need to approve this particular application, thinking the children on the back of everything. Thank you.
Do you have a second for Councillor Carraday's proposal?
Yeah, thank you, Chairman. I'll move the recommendation as printed on the report, and I second that.
Okay. We have a similar situation as to previous applications. We have we have a proposal to approve the application, and we have a proposal to reject the application. We'll now take a vote on that. Those in favour of the application, please show. Okay. Those against? Thank you. Again, in terms of convention, as the chair of the committee, I have to support the officer's recommendation. That means that that application is approved. Have we had any advance notice of site visits?
We've received no further, Chair.
Thank you. All right. Delegated decisions.
Noted.
Councillor Gillies.
Noted, Chair.
Thank you. And that concludes our business for this evening. Thanks, members, for your attention. And